In this discussion, we're going to be talking about the exclusionary rule and how the exclusionary rule has evolved throughout the history of our country. The exclusionary rule was established in American jurisprudence code of conduct with Weeks versus the United States in 1914. Regardless of the case that was involved, which was mail fraud and other number rackets, the court stated that any evidence that's obtained from an improper police conduct would be excluded from the evidence to convict at trial. This rule would also include fruit of the poisonous tree, excluding all of the evidence obtained through the improper intrusion of Fourth Amendment rights. So not only would the illegal search be excluded and the evidence of that search be excluded, but anything that was produced from that search or that interrogation. Weeks versus United States applied this only to federal agents, and it did not apply to the local state agents. Justice Frankfurter, in a subsequent case, Wolf versus Colorado, stated that the exclusionary rule is not a protected right, but rather a judicially approved centered remedy to police actions and to police abuse. He was overruled in Mapp v. Ohio, which was in 1961. In 1961, the court ruled that the exclusionary rule was an essential and constitutionally required right and protection, and applied this to all government agents, whether it was federal or state. These two cases established the exclusionary rule. If police are oppressive, or if the police abuse the Fourth Amendment, any evidence that is created or obtained from those searches or interviews or interrogations will be excluded at trial. Over time and throughout the history of the exclusionary rule, the courts have weakened the exclusionary rule to the benefit of law enforcement. The first that they have weakened it through is what's known as the good faith exception. The good faith exception ensures that a police officer can conduct a search as long as he is acting in good faith and he's working with the interests of the people. Okay, there's a couple ways to establish the good faith exception. First is whether or not other police officers would have done the same thing in the same circumstance, if this was reasonable. And if it's reasonable within the world of law enforcement that this type of search to be done without a warrant or in order to protect society, then that was acceptable. And the most commonly, and the way that I most recommend good faith is that you're acting out on a warrant. Okay. As long as you have a warrant and you're acting within the confines of that warrant, you are acting in good faith. Even if that warrant was illegally obtained through deceit or lying or any of those other ways, the agent that is fulfilling the warrant is acting in good faith, and then any evidence that's collected will be allowed because of the good faith exception. The next way that the courts have weakened the exclusionary rule is through the balancing test. And the balancing test suggests, or it asks the court to balance the possible deterrence effect of suppression of any of this evidence and the substantial social costs of releasing a defendant, especially a guilty defendant. How is this going to protect society? One of the things that we need to learn as criminal justice professionals, whether we're cops or probation officers, parole officers, or correctional officers, our number one job is to protect the community and protect society. The courts are suggesting that as long as we are protecting society at the greater good. And the social costs of releasing a guilty defendant is heavier than that of disciplining a police officer for an oppressive act. It's more important to protect the greater community and the greater society. They have made some announcements on no-knock warrants. Most warrants have to be knock and announce. Wilson versus Arkansas required officers to knock and announce all of their presence before they enter a search. And they're talking and stating that there must be at least 15 seconds between the knock and announce and entry. You have to give the person living in the home the time and the ability to understand that the police are coming through their door. In Herring, the court said that in order to trigger the exclusionary rule, police conduct must be sufficiently deliberate that exclusion can meaningfully deter and specifically capable that such deterrence is worth the price paid to the justice system. As laid out in our cases, the exclusionary rule garners to deter or attempts to deter deliberate, reckless, and grossly negligent conduct on the part of the police, or in some circumstances, recurring or systematic negligence. We do this and we look into whether or not suppressing the evidence is going to cause more danger to the community in the future, or if this is something that's going to help deter police from oppressive behavior in the future.